Good morning, everybody, and welcome to this webinar presented by Rory Goodson and I. Both of us are members of the business and property team here at King's Chambers, and today it is our pleasure to introduce a talk on the Leasehold and Freehold Reform Act 2024.
Yes, thank you everyone for joining. I won't just say at the outset, we're not going to be conducting some sort of forensic analysis of this act. It's more going to be sort of a gentle look through some of the key points and maybe trying to draw out some themes as and where we find them going through the relevant sections of it.
Yes, indeed, that's right. And unfortunately, we won't have time for questions at the end. We don't anticipate, as we are followed closely by our colleagues presenting talks as the day goes on, and we don't want to run over our time slot. So before we do dive into the act and its mechanics, Rory, and without being on the spot for too much of an analysis, what were your initial thoughts on the act?
I think the frustrating thing about the act is that it's sort of a wait and see in many respects. A lot of what we're going to see as we go through it is it's subject to various statutory instruments and regulation that will be enacted by presumably the next government. And it's difficult to say in advance what those are going to stipulate and therefore exactly how the act's going to take effect. If you look at the various manifestos, the Labour Party appears to be looking to go further in terms of enfranchising leaseholders. Whether that means they'll seek to redo the act in some manner is hypothetical. But there is uncertainty as a result of that, because it's a sort of wash-up act really that's there with the ability for the minister to make all these regulations, but we don't know what they're going to be. So there is an element of guesswork in, without wanting to cop out exactly what we're going to say over the next half hour or so, there is an element of guesswork to it, I suppose, in that respect.
Absolutely, and I think my initial take was very much the same in terms of many of the points we'll discuss today are somewhat to be confirmed in exactly, the finer points, because there are going to be further regulation. I think I'll point out in some places this will be helpful. In others, it will simply be uncertainty. I've kept my ear to the ground in terms of the reactions from the big players in the industry. For example, the Royal Institute of Chartered Surveyors, RICS, and they've come back generally positive, but they do express much the frustration that Rory's just expressed, that really we are on a bit of a cliffhanger. And so, it does remain to be seen. And I think that's a fair summary. Although my take is that in broad terms, it is a really serious effort at modernising the law, essentially especially the banning of new leasehold homes going forwards. I think it's a huge leap in the right direction, trying to modernise, English and Welsh property law, which at the minute is so outdated and antiquated. It's difficult to explain, but there you are. It's a step in the right direction. In terms of the other thoughts that have been coming from the commentary and that's available, it is the potential for human rights challenges on certain elements of the law, particularly on enfranchisement, which is what Rory is going to be looking at in terms of Article 1, Part 1, and the right to peaceful enjoyment of possessions without state interference. I've heard it said by individuals more learned than I that this will be an area ripe for the picking for human rights challenges in terms of how things are calculated and how exactly that will work. So I think it's fair to say at the outset that firstly, we are dependent on how exactly these regulations come out, and secondly, that you can expect to see some serious challenges to this legislation going forwards. So with all that in mind, our email addresses are here on the slides. So afterwards, if you do have any questions, feel free to send them over. We'd be more than happy to field them and discuss them and see if we can come up with an answer. And it may well be that we are in the dark due to the lack of regulation, but we certainly will do our best, and it would be great to hear from everyone regardless. So our email addresses will be there, and I understand the slides as the talk will be going out, so that they'll be there to come back to. Firstly, over to Rory with a word on commencement.
Yes, the point on commencement is one, not only do we not know a lot about what various provisions are going to be, but of course the vast majority of the Act isn't in force yet. The 1243 section that you see there on your screen shows that other than those specific sections which come into force 2 months after the Act, which I think is at some point in July, the rest of the provisions are at the behest of the Secretary of State when the regulations are set out and when those various provisions then come into force. So the Act's there and will come into force, presumably at some stage, with the various regulations for the manner in which it does so. But it's not in force yet, certainly in terms of a lot of the most significant elements of it that we'll be running through throughout this talk.
Absolutely. So hopefully we don't lose too many of you at this point after saying most of it's not in force yet. But I will make a start now looking at part 1 of the Act, a ban on the granting of a assignment of long leases, 21 years or more, of residential houses. Again, this is really what I set out to point out in the opening, that this is a huge step forward in banning this practice that's existed in England and Wales for, forever, essentially. And that's now gone, which I think is a step in the right direction. But we have to look, of course, through the various parts of this Act as to how exactly this is going to be defined and enforced. Section 3, I would probably opinion, does a relatively good job of setting out an expansive definition of what is a long lease. For example, it does close some loopholes. For example, perpetual renewals. One can imagine a situation whereby a lease is set at 20 years with provision to automatically renew, etc. And it even covers an event where there's a series of leases that have sort of in some convoluted effort to avoid the ban. And Section 4, if you have time to look at that expands on how exactly that will be covered. So, in my opinion, the law does do a relatively good job of avoiding clever workarounds. But, of course, I said I've been keeping my ears to the ground in terms of the reception, and I've read something that I agree with, actually. It does remain to be seen some of the finer points as to whether or not houses sold on a flat-style lease, where the structure itself is perhaps not demised, will be covered. For example, where there's a shared roof and structure, will this escape the rules? We'll have to wait and see. But the Act does specifically allow the Secretary of State to make amendment to the definition. So any cracks that do start to appear, in theory, could be closed again in short order. Again, it's a case of we will see. But I do take the view that this will be a fairly broadly interpreted Act, and it will have broad application. So if there are any gaps, I think it's fair to say we can expect them to be closed relatively quickly. Of course, there are exceptions. This ban couldn't and doesn't set out to ban all types of lease. That there are 2 categories set out in Schedule 1 in Part 1 and 2. Part 1 is what's set out on the slide there. And the obvious ones are the last 3: community housing, retirement housing, and national trust property. And we can all see why that there might be circumstances where we would want long leases to continue. So those have been taken out of the requirements. So they will be called, as will the leases in Part 2, a permitted lease. Now, the Part 1 exceptions that we see here require you to get a certificate from the appropriate tribunal, which we understand will be the first tier tribunal, whereas Part 2 is a form of self-certification. Now, we'll come on to that in a moment, but that's the broad structure. It's not the purpose of this talk to delve into how these exceptions work and where any gaps may appear, simply to point out really that they exist. I don't anticipate there will be too much trouble in how exactly this is implemented, but who knows where the challenges may come from. Part 2, I should say, includes leases agreed before commencement, shared ownership leases, and agricultural leases. So again, you don't have to go to the first tier tribunal to have those types of permitted leases. it's the self-certification, which we'll come on to. So this section 9, I've headed it certificates and marketing, where you do have a permitted lease. As you imagine, certain rules apply, and this is the start of the red tape that the Act that brings in. In short, you cannot market the property without giving the permitted lease information. Section 9 freeholds that you must give information of to which category it falls under, and if you're a Part 1 exemption, a copy of the certificate, and if you're Part 2, a statement basically attesting to the fact that you fit under one of those exceptions. So this self-certification idea. It's possible to see how parties may quibble over exactly how this is complied with, but broadly speaking, I think it's a step in the right direction as to transparency, which is sort of a theme that runs through the Act. So a question of what on earth is a permitted lease certificate, that is covered in Section 8. And this really looks at how the appropriate tribunal will issue the certificate. So it seems to me that the legislation envisages the home builder applying for such certificate, setting out why Schedule 1 applies, then obtaining a certificate, and then marketing the property essentially with that certificate stapled to the back of the brochure. That's how I see things working. The red tape, I say, goes on. Section 10, which isn't on the slide, sets out how when an agreement is entered into to enter into such a permitted lease, certain warning notices, I put these in inverted commas because as you'll come on, it's not clear what they are, must be given to the proposed tenant, and the grantor must obtain notice of receipt from the proposed tenants. The contents of the warning notice are broadly similar to what we see with the marketing requirements. A copy of the certificate, explanation of how it fits into the Schedule 1 exceptions, etc. And Section 10 does expressly hold that a failure to adhere to this does not affect the validity of the lease. We'll come on to enforcement in a moment, but it isn't the case that such leases will be null and void. Again, this all looks fine in practice, but it's one thing that I've spotted. It's not clear what a landlord will necessarily do if the proposed tenant refuses to return a notice of receipt. I suppose in that circumstance they may say, well, you're not having the lease, but if things have gone too far, I'm not quite sure where the parties will end up. So it is perhaps an idealistic part of the Act in what might happen, but what one can already see where issues may arise. Again, something not expressly covered on the slides. Section 11 is worthy of note, especially for any non-contentious lawyers listening, and that when the lease is drafted, it must contain a prescribed statement, which will be confirmed in regulations to come. So not only is there rules as to how it's marketed, there's also rules as what you need to do as it goes on and what actually ends up in the lease. So it really seems to me to be a start to finish regulation in what needs to be done. That's all well and good. How will this be enforced? Well, Section 13 is really where the teeth of the Act lay. That this basically says that when a lease is granted or assigned when it shouldn't have been, i.e. it doesn't follow any of the exceptions, the leaseholder has the right to the freeholder for free. And it's also prohibited to contract out of this right. So this sort of this right to remedy this will always exist. How will this work? Well, this is one of the bigger legislation cliffhangers. If you're interested, go to Section 16.2. This says what the Secretary of State may issue regulations on. And I think if you want to actually get an idea of just how, in some ways, incomplete this Act is and reliant on future regulations, take a look at Section 16, because it sets out there, Section 16.2, subheadings that run all the way from A to Q, just under the first subparagraph, what areas the Secretary of State may release regulations on. So any subparagraph that runs to the letter Q, in my mind, is significant, and these are the gaps in the legislation at present. So the right to acquire is going to be a huge deal, but exactly how it works is subject to so much more regulation. So it really is difficult at this time to properly see how exactly it will work. But the I think that the most important bit for me is the first bid on the shopping list for that is the period within which the right to acquire must be exercised. So if one is granted a lease that isn't a permitted lease, can you 10 years down the line say, well, oh, just a minute, I've been told that you should have granted this. Can I have a freehold, please? There's likely to be a limit placed on that, sort of a limitation period, if you will, but it remains to be seen exactly how long that will be. So we will have to see. Enforcement generally, it's going to be enforced by the local weights and measures authorities, trading standards. And again, the Secretary of State could designate one of these to be the lead enforcement agency. So whether or not we'll see, for example, Central London Trading Standards Authority taking up the mantle to be some sort of national enforcement agency, I don't know. That will obviously be a policy decision for whoever's in government next. But that could have, in and of itself, a significant effect on how closely this is regulated and looked at, which in itself will affect how much sort of litigation is generated off the back of this. Financial penalties, they're defined in Section 17, but the fines can be up to £30,000. So this is a really, really significant matter. And also, the Act expressly covers what will constitute multiple breaches, and it seems to me that it's covered in such a way that it won't be difficult to fall into multiple breach territory. So if we do find ourselves advising would-be landlords, they could be facing £30,000 several times over if they don't get things right. In terms of how exactly this will work, Schedule 2 does give some guidance. Essentially, there'll be a 6-year limitation period on such an action. Defendants, i.e. the landlord, can make written representation with 28 days, and there will be appeals permitted to the first-tier tribunal within 28 days' notice of the conclusion of that. So there is a full mechanism there for essentially appealing and challenging these breaches. So my conclusion of part 1, for what it's worth, of course, we have a ban on long leaseholds and some fairly stringent or potentially very stringent regulations on how one markets property thereafter. And of course, there are really serious repercussions, including the right to acquire the freehold title, which is not to be overlooked. In terms of looking forward to the future where the issues may be, the quantum of fines, quantum of these, £30,000 or £500 or where in between, clearly that's going to be very contentious. One could think of, as a comparison, the AST regulations in respect of tenancy deposits. That's much simpler. It's either 1 month, 2 months or 3 months rent. And of course, it's not difficult in those circumstances to weigh up where you might fit on the scale. Here, of course, we have a blank canvas, and it will be for everybody, all advocates, to make all sorts of weird and wonderful points as to where they fall on that scale. So in terms of advising clients, I would say hope for the best and plan for the worst. And likewise, in terms of the appeals, how exactly they're going to be handled, and how the authorities are going to fall on that point. Some uncertainty, but it does, in my mind, make for a huge leap forwards in modernising the law. So those are my views on part 1. And now over to part 2 with Rory.
Thanks, Harry. Yes, we've been trying to... Harry's in charge of the slides, so we've been trying to rehearse any sort of hint that I'll give him to nudge me onto the next slide. So hopefully this will look really smooth, but we'll just have to see how we go. In terms of the headline on part 2, it's a significant expansion on the ability of the leaseholders to claim extensions and enfranchisements, and that's the basic headline. There's a lot of quite technical elements to this, and I'm going to run through it pretty much section by section just to flag up the various points within it that I think are worth highlighting. There's also within it a standardized measure for calculating valuations, the standard valuation method, the imaginatively named standard valuation method. I'm going to flag up how this works in general, It's one of those things, as with so much of this Act, that is subject to the Secretary of State setting down what is the deferment rates, and which are part of the calculation within this standard valuation. So again, there's that element of uncertainty that we keep coming back to. But we'll get to that in due course. It's in the rather intimidating Schedule 4, and we'll get there in due course. But I'm just going to start with Section 27, which is the first part of this this part of the Act. And the headline provision here is one that I'm sure many of you are aware of and has been much talked about in relation to this Act. And it's the removal of the previous 2-year requirement in order to claim the enfranchisement or the extension of a term. That was previously under the 93 Act. The question of a qualifying tenant and requiring to have been in occupation for the period of 2 years before you can make your claim in respect of extension or enfranchisement. That's removed by Section 27. It enables a leaseholder to seek to claim these rights immediately upon taking hold of the leasehold. Now clearly that's a fairly significant expansion of the rights that the leaseholder has and the ability of the leaseholder to assert those rights immediately upon taking hold of the leasehold. We'll go into now the mechanisms by which that's done. Section 28, again, is a removal of restrictions that were previously in place upon the leaseholder's ability to exercise these rights in terms of enfranchisement and lease extension. Previously, the sections, I think it's 16 and 20 of the 67 Act and 13 and 42 of the 93 Act, placed restrictions on the timing of applications. There was one 50-year extension that was permitted in terms of leases, and where a claim had been made, there was then the 1-year bar before a claim could be brought again. Section 28 does away with both of those. Those are both stripped out. So again, what we're seeing is an expansion of the ability, an extension of the ability of the leaseholder to assert these rights in terms of enfranchisement and lease extension as against the freeholder. And this is a theme throughout Part 2. Section 29 relates to collective enfranchisement. It's a very short provision, but I think it may be one of the most significant provisions of the Act for one reason. Previously, when it came to collective enfranchisement, there was the limit on non-residential space within the claim of 25%. And where the non-residential space was more than that, then the collective enfranchisement claim was barred. That has been increased within the Act that we're talking about today, up to 50%. That could bring a significant number of freeholds and properties within the scope of a collective enfranchisement claim, properties that may not have been attainable in terms of purchasing the freehold, and potentially higher value properties as well. It's unclear to say at the outset exactly what the impact of this will be. But it is, again, as we've seen with the previous two, it's a powerful extension of the right of leaseholders to assert these rights. And it extends the scope of property over which they can be extended. We've seen the temporal extension in the previous two sections. And now here we have an extension over the scope of property that these rights can be enforced. Section 30, again, is dealing with the rights of freeholders in respect of opposing some of these claims. And within Schedule 3 and Schedule 8 as well, we don't only have the expansion of the eligibility of enfranchisement, but we also have a narrowing of the basis on which the freeholder can then oppose these claims. In particular, we had the previous redevelopment and reoccupation provisions under the 93 and particularly the 67 Act. These sections are removed and stripped out by the new Act. The ability to oppose these claims on those old bases is taken out. And what we have is a new right of redevelopment, which is set out within Schedule 8 to the Act. I'm not going to go through Schedule 8 in great depth, but the point, or some of the headline points within it, is that this right of redevelopment exists within the last 12 months of an original term, or alternatively, within the last 5 years of each 90-year break period of the extended 990-year term. We're going to get on in a couple of sections to this new 990-year term as the standard term of extension of leaseholds. But again, this is clearly a very significant reduction on the ability of landlords or freeholders to oppose these claims when they're brought. We have the extension of the ability to bring these claims, and again, we have a restriction on the ability of freeholders to oppose them. I've flagged up there a point regarding certified community housing providers. This takes up a fair bit of space within Schedule 3. The implications of it are almost entirely subject to regulations that will be set down by the Secretary of State in due course. So beyond flagging that it could well be of some significance in terms of the roles that they play and the different regulations that apply to them, it's very difficult at this stage to anticipate what those are likely to be. There's plenty more within Schedule 3 exceptions to this. There's a large amount, I know Harry mentioned it earlier in relation to something else, large amount in relation to national trust property. I imagine that's only applies to a very, very small minority of practitioners who deal with that kind of area. But that has its own schedule within a schedule, if you like. I'm setting out various different regulations, but it's worth being aware of in any case. Section 31 deals with, within a collective enfranchisement claim, the obligation or ability to of the nominated purchaser to purchase intermediate interests when they're undertaking one of these claims. There's a reasonable necessity test in here at paragraph 3.3 of Schedule A1, which is what this section inserts into the 93 Act in terms of whether it's reasonably necessary for that intermediate interest to be rolled into the collective enfranchisement. Again, it's part of this trend of an attempt to modernise and simplify the overall workings of the scheme. The obligations to take hold of these intermediate interests, and I've highlighted there within the slide when it's required that these things take place, tend to be when there's an almost entire overlap between what is demised under the intermediate interest and what is demised under the leasehold interest underneath it. And it's an attempt to roll these in together and start to remove some of the layers within the property ownership system, which this Act in general is targeted in many respects at trying to remove. Sections 32 to 34 are a series of, I've called them their self-contained amendments, in the sense that they are, they don't necessarily have knock-on effects in terms of a wide variety of other sections. See there, Section 33 is the extended lease term of 990 years. That's now standard across flats and houses rather than the differing terms that were previously in place. And that does tie back into the reoccupation and redevelopment right, the new right within Schedule 3, in terms of the 90-year break periods that are then built into that 990-year term and the ability to then oppose a claim on that basis. The requirement for leaseback provision within Section 32 has the potential to be very significant. Rather than the question of leaseback or non-participating units being within the discretion of the freeholder, what we have now is the ability of the nominee purchaser within a collective enfranchisement claim to foist upon the freeholder a lease back on a 999-year term at a peppercorn rent of non-participating units. This provision covers commercial as well as residential units. The basic intention of that provision is to reduce the overall price of undertaking these schemes and to expand the ability of leaseholders to assert their rights in this respect. And I think it's likely to be quite powerful in doing that. There is a question about the extent to which being able to enforce those 999-year terms and to enforce the lease back may be unhelpful in terms of creating new interests, which the Act is intended to remove. But that may be a slightly separate point. Section 34, I've only highlighted very, very briefly there, but it's a provision in terms of extensions and how it brings flats and houses into line with each other and equates those provisions together. I'm going to move on slightly quickly because I appreciate I may be taking slightly longer than I'd anticipated on this. And this may be the point within part 2 that is of most significance. And this is where we get to the standard valuation method. What we have within this is a new attempt at providing a method for valuing all of these properties and all of these interests that can apply to enfranchisement, extension, claims. Whereas previously there have been various different methods of doing so, and there are exceptions within this Act, what this seeks to do is provide a simple, I use inverted commas on that, 3-step process for calculating the premiums of these values and the market value within Schedule 4 of the Act. There's also the other compensation provision within Schedule 5, which can be broadly summarised as diminutions in value in respect of other interests, and it covers development value as well. The 3 steps within Schedule 4, and I've set them out there, but it's worth going into it yourself. Step 1 is to work out the value of the rent and remain in terms of the remainder of the term. Then enfranchisement and extensions are dealt with in separate paragraphs of 27 and 28. These have specific formulae in terms of calculating the manner in which this value is then to be added on. This is where I stated earlier that the standard valuation method is slightly uncertain at this stage, because within those calculations we have the applicable deferment rate. The deferment rate is subject to statutory instrument, and so it's not possible really to anticipate how high or low that's likely to be. And step 3 is adding those previous 2 numbers together. There are variations and there are exceptions within particularly particularly parts 3 and 4 of Schedule 4 as to when the standard valuation method does and doesn't apply. But it's clearly an attempt, as we see throughout the remainder of the Act, to standardise the system in relation to leaseholders and freeholders and try and bring things into a more modern frame. I'll just briefly touch on this final slide in relation to Part 2. Landlords' costs in relation to these claims are set out within sections 38 and 39 of the Act. Failed claims, a tenant will not be liable in respect of failed claims for their costs unless they failed for a non-permitted reason. There is a schedule of permitted reasons as to why a claim may fail. If it's not a permitted reason, then costs may bite there. And I've also just pointed out there in terms of the jurisdiction provisions, the vast majority of disputes are going to go before the tribunal. And under Section 44, where the tribunal does have the jurisdiction, there's no first instance right to apply to the High Court in respect to those sections. So just to briefly conclude in terms of Part 2, it is clearly a significant expansion in terms of the rights of leaseholders to assert enfranchisement and extension rights. There's a shortening of waiting periods. There's an expansion of where and when they can be applied, and a reduction on the the freeholder's ability to resist them. We also have this standardized valuation method, likely to reduce costs, but it will depend on the rate levels, the deferment rate levels that are set by statutory instrument. And at this point, we simply don't know what those are going to be. So I'm going to hand back to Harry now, because I think he briefly is going to touch on part 3 of the Act.
Thank you, Rory. Yes, indeed. Part 3, which I have, in an effort to sort of curtail the length of this talk a little bit and to keep our audience awake, I have limited to one very discrete element of it. Part 3 is headed Other Rights of Long Leaseholders, and it does do quite a few things. So I would recommend that you have a look when you get a moment to see the various things it does. It's not possible for us to cover them all. So what I've done is simply picked what I see as one of the more significant of them, and that is, in short, qualified tenants whose existing lease has at least 150 years of its term remaining will have the new right to vary the lease to provide for a peppercorn rent in place of the existing rent on the payment of a premium, subject to exceptions. This will be a standalone right, can be exercised without the tenant claiming a lease extension or enfranchising, and indeed can't be done at the same time. So it's a standalone remedy, if we call it that. The significant point here is that the premium for this will be determined using the standard valuation method that Rory's just run through. So I think it's fair to say that if one does want to get oneself ahead of the game in terms of understanding of its act, ready for when it does finally come into force in dribs and drabs, if that's going to go, that having a good understanding of the standard valuation method, especially once the regulations are out, will put you in good stead to navigate both part 2 and part 3. But as I say, and as Rory's neatly laid out, we are awaiting further regulation on that. So unfortunately, it's not possible for me to sort of delve into that, save for at the outset we mentioned potential human rights challenges, and it's these two sections really where I see it as most ripe for challenge because of the valuation on these leases and how exactly that will be determined. But again, at the risk of sounding like a broken record, we will have to see how the regulations come out. So back to Rory now for part 4.
So yeah, I'm conscious of time, so I'll try and deal with part 4 maybe slightly more briskly than had been anticipated. In general, this is a wide variety of measures that deal with the regulation of leaseholds, and in large part are providing more administrative requirements upon freeholders in terms of information that needs to be provided and the ability of leaseholders to then enforce those rights to the provision of information. You'll see there I've highlighted section 71. It applies to leaseholds pre and post dating the Act. In terms of that next slide, it's sections 53 and 54. The protections in terms of service charges are extended across then to fixed service charges, whereas previously they applied only to variable service charges. Where demand notices are being provided in terms of service charges, there's provision for a standard form and a standard procedure for that. Unfortunately, and throughout this entire section, I'm going to be saying this a fair bit, the statutory instrument will be required to set out exactly what is required and when it's required and how it is required. It's a fairly skeletal provision, but it does highlight that is a new obligation that applies to freeholders. The next slide and the obligations that I've highlighted there in relation to the provision of information and the in terms of insurance, but again, this will be subject to statutory instrument in due course. That's in sections 59 and 60. Administration charges must be in a fixed schedule and they must be provided in advance. And under section 67, there is a right to request sales information in respect of the property. I can't flesh out these sections particularly, in large part because they aren't particularly fleshed out. they are going to be, as I say, subject to statutory instrument in due course, and the manner in which they will be applicable will obviously depend on those. What we do have in various sections in relation to all of those obligations is the statutory ability for the leaseholder to enforce these rights. Each of these has the provision for specific performance that the leaseholder can seek to have enforced upon the landlord. And there's also provision for damages. I've noted there in respect of service charge insurance and sales information regulations, those damages can be up to £5,000. In relation to administration charges, those can be up to £1,000. There's also provision within sections 62 to 64 that deal with litigation and non-litigation costs. There's a bar on charging non-litigation costs within service or maintenance charges on the leaseholder. And in terms of litigation costs, sections 62 and 63 deal with that. But again, there's a lot of provision and there's a lot of mention within those sections that these are going to be subject to regulations that will be set out by the Secretary of State in due course. So it's difficult to really flesh out exactly what the impact of those is going to be in terms of Part 4. But I think it does, as I've set out there in the conclusions, it does play into this broader trend, which is attempting to standardise regulation across the board and the obligations, but also strengthen the rights of the leaseholders that can be enforced against freeholders. And we see those enforceability provisions making clear that they can be expressly enforced. So I'll leave it there and pass back to Harry, who's going to deal now with Part 5.
Thank you, Rory. Yes, Rory, they're dealing with issue of service charges under leases, something we're all familiar with. There's nothing new or respectfully to Rory, exciting about that. But if I can call anything exciting, perhaps it's Part 5, which deals with estate management. Now, what this is rather than a leasehold, the lease requiring service charges, this relates to when freehold owners have an obligation to pay estate management charges. These most commonly we see now in new build developments. The homeowners there are often, or indeed it seems to me to be the norm, required to pay a service charge, often quarterly, to pay for maintenance of common areas and things such as that. It really just seems to be the norm. And I think with the constant growth of new build developments in the country, certainly it is near where I live in Kirklees, this is going to become a bigger and bigger issue. Previously, this sort of thing was relatively unregulated, but I think that the government, or as was, have now seen, well, we're forcing all these new build developments, we ought to really step in and regulate who can charge what. So it very much is in a similar vein to what Rory's set out in terms of leasehold, but just bear in mind that this is relatively new and does go quite far. One shortfall I will point out at the outset is that it does pull up short of confirming a right to take over the management of the estate through some sort of right to manage company. Often homeowners are allowed to set this up. This is something that's granted to them as right through the contracts, but where it's not, this act does not go as far as to give them that chance. So if Rory's was a canter, mine's going to be more of a rising trot through these slides. The Act separates out administration charges from estate management charges. Essentially, what it says about administration charges is you can agree to fixed fees at the outset, for example, assigning a lease or a change of occupiers, the sort of things you can perceive coming up. And these won't be subject to challenges. There are, in terms of other administration charges, stringent requirements, which are very similar to what Rory set out, and there are sanctions of up to £1,000 if you don't follow them. And again, it's all about transparency. But where I've focused on today is estate management charges. And this is set out quite broadly. It's subsection 11, which is of section 71 at the bottom, which says relevant costs in relation to a dwelling means costs which are incurred by an estate management, essentially for the benefit of the dwelling and of a dwelling. So it's really broad and somewhat of a catch-all provision for anything that can't be called a administration charge. There's now a statutory limit on those charge. And as you can see there, it is down to reasonableness, that word that crops up throughout legislation and authorities and doesn't give us much guidance. Section 76 tells us, if you have a look at that the first tier tribunal will be the arena in which we can challenge these charges. So far, so good. It does seek to regulate what is clearly a expanding area. But there is some serious red tape, and much like the other red tape we pointed out, it's red tape that we can't really see at the moment because it's all to be confirmed by regulations. And I think this is one area that's particularly vulnerable to that criticism. Further obligations we see, there'll be consultation requirements when the costs exceed the appropriate amount. How much is that? Who knows? There'll be a time limit on pursuing charges of 18 months. This seems eminently sensible to me. It saves estate management companies falling idle for 3 years and then claiming sort of back taxes, which can lead to trouble. And the third one is demands must be in some form of specified form with specified information, again, to be confirmed. So it's clear that the Act has ambitions, but also clear that it was done in a rush before Parliament ended. And again, we go on annual reports, and again, requests for information can be given by the freeholder, and they will have to be responded to. So there is going to be a lot of red tape. I would offer up the opinion this is very good news and is certainly required. But as for how it will work, again, we will see. Enforcement, again, we can see damages up to £5,000. So there will be some serious teeth to this in terms of finances. But perhaps one of the more interesting is the replacement of a estate manager. So to put this in terms, one can imagine a situation where a large company builds 100 new build homes and they set up management company A to manage it. It's not a particularly good company. It's one of these that's been set up to try and profiteer essentially from this new setup. And the owners all get together and say, no, we want to change your management. And the Act sets out how it can do that. But there does need to be a notice of complaint and then a final warning notice. So inevitably, there will be quibbles as to whether or not that's all been complied with. And especially in circumstances where you can foresee this will be done by litigants in person, I would suggest that there will be fun times ahead in terms of how exactly this is going to work, or indeed how well it's going to work. So that's that. Now on to Rory for the final substantive piece of this presentation. You'll be pleased to hear part 6.
This is just a very brief point, and it tacks on to what Harry was just saying in terms of the Part 6 provides for regulations can be made in terms of obligating estate managers to be members of stipulated redress schemes, so long as they're not acting as tenants or agents. And there is provision for significant financial penalties if an estate manager is not in compliance with these. As you can see there, up to £30,000. But again, this is may by regulations require. It's all subject to the statutory instruments, and so I just wanted to flag that at the end there, Harry, just to tack on to what you were just saying.
Thank you, Rory. And as a closing note, again, with our apologies that much of this has to be caveated, we'll have to wait for the regulations. I think Rory and I discussed it at some length in terms of what sort of takeaway points we can give today. And I think where we arrived at is that it's important that for the time being, as practitioners, we understand the framework. I think Rory's called it skeletal in part, which is probably right. The framework of where we are with this new Act, so that when new and exciting regulations pop up, we hit the ground running. And we're ready to advise our clients and act accordingly, because, of course, we don't know how quickly these will be implemented. I should say some are subject to a negative procedure, some to a positive procedure, which will require passage through the House. But I don't have the stats to hand, but it's very rare for these things to ever hit any real hurdles on the way to being passed. So we can anticipate regulations being passed pretty quickly. So there you are. That's what we would say on that. I hope that's been of some use. Thank you everyone for listening, and hope to see you soon.